When there's an injustice against you or someone you love or someone you believe in, stand up. Don't sit down on them, if they need you.
Welcome to Popcorn Planet's Pop Culture Justice. I am Andy Signore, and I'm so happy to be here with Christopher Melcher, attorney at law. How you doing, Chris?
Pretty good, Andy.
This is where it just keeps on going. Everybody wants us to react to all these briefs and replies, but there was one today that did drop, and I thought it was pretty worthy of talking about because it does really feel to me like they came after Amber pretty hard, as expected they would. But before we even get there, we've gone through the appeals, guys. We've gone through a lot of stuff. We're going to go through all of them. But I do want to today, it's the holiday season. I'm going to be promoting them a lot this season, I hope. But I want to make sure you guys go get your holiday sheaths. What? Oh, yeah, the sheath iceberg is now available. Look at that guy going in the freezing water, and his package is just fully intact. Guys, this is my favorite underwear in the world. They have outfitted me like crazy, and all you guys that have bought sheath underwear over the year now have just given me the best raves and reviews. It's got, guys, they took away the where's the section where they show? There it is. Guys, it's got a pouch. It's got a pouch for the boys and a hole for the other piece. Sorry, Chris. It's like I said, listen to this. But I got to get you a pair, Christopher. I'm going to get you some sheath underwear so even you can attempt to try this because, guys, it's so damn comfortable. And they got some amazing designs for the holidays. Perfect gift for someone if you're looking for a holiday gift. And make sure if you go to sheathunderwear.com, you use code POPCORNED at checkout. You can get a lot of good discounts. You'll get a great discount. I forget the exact amount, but put it in there. You'll be supporting Popcorn Planet as well as our sponsors over at Sheath, who are amazing. And ladies, they got stuff for you as well. So go check out the women's briefs, the boy shorts, the tops. My lady loves it. I know Steph and Kim have been impressed, and everybody who sends over there on Sheath, it's amazing. So go check out the most comfortable underwear you're going to get. Mark my words, I'm telling you, because I'm wearing them right now. So go to sheathunderwear.com and use code popcorn at the checkout. Mods, thank you for sharing that. All right, but I want to get into this right away. Let's get to it because Sheath's amazing, but this is even more exciting because it's nice to see. This was written by Ben, right, Christopher?
Yeah, it's really well done. So what's going on is that, you know, we saw before that Amber filed her appellate brief, you know, raising all kinds of issues. And then we saw these two groups file separate, what we call amicus briefs. They're friend of the court briefs trying to illuminate various issues. They were very, very lengthy. And they need permission from the court to file those things. They go ahead and file it, and then the court eventually rules on whether they're going to allow these non-parties, these groups of people to, interject their ideas into this appeal. And so here we have, on behalf of Johnny Depp, Ben Chu giving a really hard-hitting and I think well-done opposition saying, hey, Court of Appeal, you should not allow these groups to be heard because, various reasons that we're going to go through.
So again, yeah, all these briefs and things that I've been going through, we've been documenting all these appeals and things, but this was, do they have to file this sort of reply to the brief? Is that required, or is this sort of a tactic to get their word heard on the record?
Yeah. So in kind of high stakes appeals or really interesting issues, we will see other groups come in to a court of appeal and saying, hey, I have, a take on this that you guys should really hear. I do that myself in my practice. So there's nothing, unusual about that in a big appeal. And so what normally happens is that the court will consider these briefs because, like I say, in a normal situation, it's some group, like maybe it's a employers' rights or employees' rights group that have very specific knowledge, and they're coming in and putting their input in, and it's done on a very specific issue. And so the Court of Appeal is going to say, sure, we'll listen to that. And then the other side, will say, hey, that's not really a good opinion, and they take issue with it. Here, what Ben's doing is really coming in procedurally and saying that these briefs do not comply with Virginia rules for amicus briefs, so they violated the rules, and that these are not unbiased opinions by special interest groups, that these folks are working with Amber And so they're almost acting like a party to give Amber an advantage in terms of the amount of material that she can present to the court, because there's limits on the page. There's a page limit, word count, all this stuff that appellate briefs have to comply with. And Chu is saying that Amber is doing an end run around that by collaborating with these groups. We'll get into that. And then as to the subject matter of the briefs, Chu's saying, look, it's all a bunch of irrelevant stuff. It's their position, it has nothing to do with the appeal and should not be given any weight.
So again, to remind people on this, how do I say amici? Like Don Amici? Is that how we'd say it?
Yeah. So it's the singular is amicus, and then the plural, people will say amici or amici. There's not necessarily agreement, but most people will say amici.
So it's very close to Amica cream. Could that have been why she said it wrong? Because she was using the Amica brief?
Yeah, that's a whole other craziness there.
Don't confuse it with the Amica cream or Don Amici. Okay. Amici's? I'm doing that right? Amici's?
Yeah, I think it's a pizza place.
Close enough. Close enough. All right. Well, the Amica brief, I'm just going to own it and call it the Amica brief. So he goes in and explains all these organizations that came forward to sort of speak on behalf of Amber, which again, I didn't understand any of this was relevant. And the motion for leave to file amicus brief filed for the Amici collectively stating as follows: this is a kitchen sink appeal. The appellant purporting to assert no fewer than 16 assignments of error. Now, I know what this means. Like, correct me if I'm wrong. The kitchen sink appeal, when I read this, is just such a knock, because it's like you're throwing everything in, including the kitchen sink. That's what the old phrase is, right? The adage. And when I read this, I felt the same way. Like, let's just throw it all on the wall. We'll see what sticks. And he's just calling it out. Line one. Was this a smart move to just blatantly call it what it is? Do you feel like it is a kitchen sink appeal?
Absolutely, it is. And it's right for Chu to point that out. And it's poor advocacy by Amber's attorneys. Sure, like you can look at or consider these 16, alleged errors and internally as a team. But then you got to decide what you're going to go with. And the judges get fatigued when they have to listen to all this. You should have 1, 2, 3 hard-hitting, really solid arguments, and then the court's going to invest its time to look at that. But when you say 16, it's like, okay, that there, and we've gone through this before, so many of those are weak. The court gets, again, fatigued, and it says like this, and all the good arguments get watered down or maybe even lost because all these bad ones. So very, very poor advocacy by Amber to do that. And, like you've noted, some of this might be really a press release, disguised as a brief, just as saying, look, I'm going to throw all this out there so the press picks up on it to say how horrible this trial was.
Yeah, and there's a lot. I'm going to go through a lot, and I also want to give props because Larry of the DUI guy, you guys, I'm going to try to get him on later in the show. I think he's going to come in a bit, but yeah, he's also just pointing out, not only are we going to get into this, but there's apparently they did it improperly. There was a lot of sections they did incorrectly, and apparently they're in violation of the appeals rule, and the court can impose our harshest dismissal. Anyway, the didn't contain a lot of the things. So, but we'll get to it all. I just want to give him a prop because he had a good video breaking this down first. But all right, so here it is. She's represented by 2 large and well-regarded law firms, is seeking to relitigate virtually every major ruling made by 2 distinguished and highly respected chief judges of Fairfax County, the Honorable Bruce B. White and Honorable Penny Escardi, over the course of a 3-year litigation and 6-week trial, in addition to the oversight brief of 55 pages that Ms. Heard has filed in support of her appeal. The Amici seek to present a collective 93 pages of additional argument in support of Ms. Heard's positions. If the motions were granted, Mr. Depp would be required to respond to a total of 148 pages with his own brief, which presently is set at 55. Now, again, 2 things I noticed, right? He's calling out how ridiculous, how much time she's wasting, how many pages she's wasting. She's not being brief, but also he's doing a really good job here at hyping up the courts, which is only going to help matters, I would imagine, right? Because Team Amber's saying, oh, Judge, Ascardi was wrong. Everyone in the court's lying. They're wrong. Ben's choosing to go the other approach, which is no, they were highly distinguished, respected judges who did their job properly. Is this a wise move on his part?
Well, yeah. So what he's really getting at is the unfairness to the court and to Johnny to have to read all this stuff. And the appellate briefs are limited by size. So here in Virginia, it's 55 pages, and it's like, that's a lot of space, right, to make your case. And Amber went over the 55 pages, and then she's collaborating with these two groups who have now put in 93 pages of stuff. And so what Chu's saying is like, wow, number one, the court's got to read all this, which is really unnecessary. And Johnny has to respond to it, but he's limited to 55 pages. Now, he could get, leave or permission to file a longer brief, but it just puts a huge burden on all these justices to read all this stuff. And what we're going to see a little bit later here is that 93 pages of additional argument by the amicus counsel is actually more than that, because the 55 pages of material is based upon using a 14-point font, and they use 12 points. So these are the games that lawyers play that are in violation of the rules to circumvent the page limits, to saying, well, we're going to use a smaller font to cram all this information in here. And that is not appreciated by the appellate court. So Chu is doing a really, really good job pointing out that these groups here that are coming and saying, we're the champion for women's rights, are actually violating the rules.
Yeah, which it really does feel like they are. Through the doubtless cases in which they previously might assist the court in resolving the issues before, this is not one of them. Mr. Depp respectfully submits that the filing of such extensive additional briefing is neither necessary nor appropriate and should not be allowed. As a threshold matter, the court should deny their motions because failed to comply with the applicable rules, neglecting to properly assign error, which violation constitutes sufficient grounds for denial. More so, Ms. Heard is very competently represented and is not in need of assistance or additional briefing in support of her position, nor should Mr. Depp be burdened with having to respond to such voluminous additional briefing. She keeps making a point of this, like she's competently represented. What is he trying to really hammer there?
Well, that's probably the weakest argument, because the appeal here by both parties raises, constitutional issues, the right of all of us to comment on public figures or matters of public interest. So it's and then we have women's rights issues, all that kind of stuff. So it's not surprising that there would be groups that would come out and saying like, hey, I have specialized knowledge for this special interest that I serve, and I can help illuminate these legal issues. And the fact that Amber has counsel is like, so what? I mean, it's like the court welcomes generally a lot of input because they want to make good decisions. So I think that's the weakest part of his argument, is saying, she can speak for herself. Sure, she can, but these other groups can and often do come in and give input. The problem, though, is that the input that they're giving isn't relevant to the appeal. So it's in an appeal is very specialized, narrowly focused issues. And as we saw when we went through the amicus briefs, they were just all over the place. A lot of, kind of alleged studies about things that are not in evidence and do not directly relate or attack specific legal conclusions or findings in the trial. So they're just kind of saying, this hurts all women, please reverse it. And it's like, that's not a legal argument. That's an emotional plea.
Interesting. Okay. And then keeping going, arguments add nothing to the legal analysis provided by appellant Heard's counsel and appear to focus instead on arguing with the jury's clear findings in favor of Mr. Depp on the underlying factual issues. Proceeds from the essential premise that Ms. Heard is a representative of domestic DV, a premise that was empathetically and soundly rejected by the jury, who paid careful attention to the evidence presented during the 6-week trial. Both briefs cherry pick evidence that they believe should have swayed the jury to a different finding, but offer the court no insight on the legal issues actually at issue in Ms. Heard's appeal. Allowing this additional briefing would merely serve to complicate, which is already a sprawling, misplaced appeal. Accordingly, Mr. Depp most respectfully requests that the court deny the Fletcher and Simpson motions. Any thoughts there?
Well, yeah, this is the problem with Amber's appeal and the amicus briefs, is they're seeking to relitigate factual issues that Amber lost at trial. And that is a non-starter on appeal, that the jury exclusively determines what the facts are, who's credible, and how to weigh that evidence. And that will not be disturbed on appeal. unless there was just like no evidence presented and a jury made a finding, well, fine. But if there is evidence there, it's up to the jury to decide who they find credible. And that's ultimately what Amber and her friends are doing in their appellate briefs, is saying the jury should have believed Amber. And that's just a ridiculous argument. So that's what Chu is pointing out there.
So now they go into arguments here. You want to help summarize these? I mean, it's not too long, but like overall, this first one, the court should deny leave because the MHG failed to comply with the applicable rules.
Yeah, so we talked about there's a page limit. They went beyond it by using a small font. So, they actually didn't comply with the page limit. The other rule violation is that they are supposed to, in an appellate brief or an amicus brief, say, here is the error that I alleged occurred. Maybe it's a jury instruction that was done improperly. They have to cite to the record, page, line, and verse, and saying, here is the instruction, and then here's my argument as to why it's error. The amicus counsel didn't cite really to any record at all, and they don't really go through and saying, here are the errors and here's I'm attacking it. This is some kind of, mansplain, women'splain maybe is more appropriate on, let me tell you what abuse is because you, a court of appeal, obviously don't know anything. And let me just give you a bunch of studies and therefore Amber should win. That's not what a brief is. That's like a term paper or something like that. So this is what Chu's going after right there.
It is right there, guys. Violated the rules by using a 12 size font rather than the 14, meaning the brief is actually even longer than it appears to be on its face, which is a clear violation. I mean, will a court take that seriously, or can people actually get away with that?
Well, it's for lawyers, we love stuff like font size and stuff like that. This is it's really exciting to us. And, so it makes a difference because we got to read, here on YouTube, we're doing all this stuff on video, but as lawyers and justices, we got to read this stuff all day long. And so we can pick up on it, to seeing wow, somebody's playing a game. They're trying to get an advantage over everyone else that's complying with the rules. It's harder to read. They're they could have asked for permission to file a longer brief, but instead they're cheating the system by making the font size smaller. And any credibility that those attorneys had coming in the door is lost when they do stuff like that.
So
it may not make difference to most people, but to us in the system, it's like, hey, there's a rule. We all got to follow by the same rules. We can argue, pro Johnny, pro Amber, but we got to follow the same rule book, and they're not doing that.
And so part 2, the court should deny leave to file the briefs because appellant is well represented and responding to the Michi would necessarily burden. This is the one you say isn't their best case.
Well, it doesn't matter that she has counsel, but the better point, and it might be made in here, is that they're collaborating. And maybe go down to the next page and see if this is where he hits it. And yes,
acting in coordination with counsel for the Michi, yes.
So this is significant. Now, again, just back up a little bit. When you have amicus counsel, you do take a position on behalf of a party typically. So there's nothing wrong with these groups saying we are support or in support of Amber. Fine. But they're not counsel for Amber. So there's naturally going to be some separation there between what Amber's doing in her brief and what the amicus counsel is doing. And when I act as amicus counsel, I try not to have really any contact or much of any contact with the side that I'm supporting because I want to maintain my, role here as an objective, kind of more neutral helper to the court on a specific legal issue, not as just a second, Me Too kind of argument. So what's happened here and what Chu is really cleverly showing is that there is much more collaboration that you would expect between Amber and these groups. Because in the amicus briefs, instead of them saying, here are the facts or our view of the facts of the case, they say, we just incorporate what Amber says in her brief. But the problem is that Amber's brief had not been filed by that time. And so they're incorporating a draft of a brief that how would they even see what she's going to say, to saying, yeah, we love what Amber said in her brief when she hadn't even filed it. So it shows close coordination. And what Shu is doing, again, really expertly, is saying this is a way of getting around the page limit. So the implication is that these two amicus groups and Amber's counsel all got together and said, hey, I'll make this argument in my brief, I'll make this in my brief, and you'll make that in your brief. And all together, we've got 150 pages of stuff that we could never have done in one brief. And that's the implication.
Yeah, I mean, that's wild because it's true. They're basically caught working together. So yeah, really good point there that I missed when I was going through this first time. Yeah, and he, there we go. So a lot of arguments and pages. That's like, why is this all here? Number 3, the court should deny because the arguments of the amici brief are irrelevant and inappropriate. I mean, is that valid? Is that it's pretty straightforward.
That is absolutely true. Like I say, for the two amicus briefs and Amber's brief, they totally missed the mark. The point of appeal is not to attack the jury's weighing of evidence or credibility determinations. Any appellate lawyer knows that. And so this is absolutely what they're doing. And coming in there, again, looks more like a term paper about, you know, these studies and stuff like that are totally irrelevant, not in evidence. In law, if you're ever, you know, in a litigation, which I hope no one has to bear, the truth doesn't matter. It matters what the jury or judge finds. And there is a distinction there. So it only matters ultimately what the judge or jury finds to be true. And so what Amber or Johnny believed to be true is totally irrelevant. What did the jury find? That's the end of it. And, you know, here we're seeing like both parties lost before the same jury. We had one judge, one jury, two cases being litigated. Amber against Johnny for the 3 Waldman statements. The jury found one of those Waldman statements to be defamatory. And then obviously Johnny against Amber for her op-ed piece. So, you know, why is this jury like out to lunch? I mean, they found for both sides. And
it's a really good point.
You know, it's just like, okay, so if we say that, you know, and this is the criticism potentially on our side, it's like if we say like, oh, the jury should have never found the Waldman statement defamatory, that they're ridiculous, they didn't know what they were doing. Well, now we're impugning or taking the weight away from the jury's finding that Amber, you know, was defamed Johnny in the 2018 op-ed piece. It's the same jury reaching these conclusions. So to say that they didn't know what they were doing, you know, they're both cheapening each other's argument. So we don't, you know, have to agree with it, but, you know, hey, this is our system. We have a trial, we surrender control to a jury and a judge over our legal dispute, and however it comes out is what we call justice.
Yeah, really well said, because yeah, it's true. If you want to call it all out, Amber, and you need a retrial, then yeah, your win also gets thrown out the window. And yeah, it's interesting because it's unfair to force Depp to use some of his limited pages in responding to these extraneous arguments. I mean, it does feel like, as you're saying here, a back and forth between Depp and these non-issue, a distraction. Do you think this will they deny him? Like, what are the odds of these things actually getting denied?
Yeah, I haven't seen it in California where I practice, unless it's just like really like somebody wrote it in crayon or something like that. It's not going to be denied. Typically, the court is just going to say, hey, more the merrier. Sure, it's a brief there. We'll grant leave. Fine. We'll consider it or read it, but they're not going to put any weight on it. And you can tell because when the opinion comes out, they're probably not going to even mention the brief or cite to it or saying like, yeah, we're going to find for Amber, like reverse the decision based on what this law professor said. So my guess is they're going to say, fine, put it in, but they're not going to give any weight to it. It's just a lot easier decision for the court to make than to saying like, yeah, because of the font size, we're tossing it. I say they're going to be bothered by it, but I think they're just going to, it's easier politically or whatever you want to, word you want to use there, just to saying, fine, file your stupid brief. We're not going to give it any weight.
So there it is. Overall, this does feel like a pretty nice, firm, aggressive fight back, and doesn't make Heard's team look well. I'm sure the media is going to ignore it like crazy. They've been saying it's a chilling effect. They've been putting that headline over the place. They won't mention the fact that Amber Heard's throwing everything she can to try and stop this thing. At the end of the day, do you still feel where you feel of where this appeal is going to net, which is probably nothing? This appeal will stick and nothing's going to happen?
Yeah, I think the verdict for both cases that were tried in Virginia are going to be upheld, and that it would include the verdict against Johnny Depp. I mean, we've talked about it, he's got some arguments, maybe they have some legs, I don't know, but ultimately, the jury decided the case based on the evidence that was presented and made findings, and those are going to be extremely difficult to be overturned by either side. So, nothing much, going on here. I think, like I say, I just kind of celebrate Chu's good work here in calling out these groups for not complying with the rules. So I think that was well done.
Great. I want a few more things I want to ask Christopher for, which we're going to do on the main show. Before I get there, thank you, Tristan King, for the 50 and saying, I always love your insight on Christopher, calling you out. I'll get to the rest of your comment in a minute, but Tristan, thank you for that. I saw it. And I do have to say before I cut this for the show, guys, don't forget sheath underwear, that iceberg. Guys, people think I saw him in the comments like, Andy, you're not telling the truth. Oh, look at that. Look at that. I told you. There it is. I'm wearing it. Guys, I wouldn't sell it to you if I didn't think it was that good. So go ahead and get your sheathunderwear.com. Use code POPCORNED for 20% off your order, and you're going to get yourself so comfortable. Christopher, I'm sending you a pair. I'm going to make sure you get to try the experience of Sheath this holiday season. Again, the real deal, fellas. Look at that. You got a pouch for one and a pouch for the and an area for the others. It seems weird, guys. When I saw this, I was like, nah. And then I did it, and I'm like, whoa. Okay. And then I've been wearing it ever since. So I really do sell these, and I appreciate them. They are sponsoring us. So thank you for helping our sponsors who come on here so they know that you guys actually support them. Sheath Underwear, I love you guys. Thanks for doing it. And I love all you guys watching. Make sure you hit that subscribe button as well. Hit the bell for all alerts. And smash the like button and leave a comment, and follow Mr. Christopher Melcher over on Twitter at @CA_divorce. Always appreciate his insight, and I can't wait to have him back as we talk about more, which we're going to do right now on the full show. So hit that join, become a member if you missed it and you're watching this later, and you can watch it all right now.